Today, rapper Pooh Shiesty is set to appear in federal court. Born Lontrell Williams Jr., he is among 9 suspects facing charges in the alleged kidnapping and robbery of fellow rapper Gucci Mane at a Dallas recording studio back in January. Williams was released from federal prison last October after serving 3 years for gun crimes in Florida. Prosecutors say a conviction this time could bring as much as life in prison.
If this report is accurate about the charge, then once he gets that violation for an armed robbery, it's very possible that he's going to go right back into federal prison. Now, Pooh's got great lawyers. Pooh has not actually formally been charged, so we'll have to wait and see what happens. Wild story, wild report.
In my years of covering hip-hop legal cases, and I've covered a lot of them, I have never seen what I'm about to describe to you. I've seen attorneys lose cases. I've seen attorneys get outmaneuvered. I've seen attorneys sit quietly while their clients got sentenced to decades behind bars. That's the business. That's the job. You win some, you lose some, and you cash the check either way.
So we had a bond hearing today and a PC hearing today. I think that the relevant things that were said today that I thought were fascinating were that it took 3 months to build a case, and I think the reason for that was because the statements that were given on the evening that this occurred were very questionable. I think the way that the statements were made, what allegedly was witnessed and what wasn't witnessed, I think gave great pause to the FBI. The FBI doesn't take 3 months to arrest someone if they believe everything that was said on the night that it occurred. They were involved the first night, and then nothing happened for 3 months. In addition to that I thought was quite embarrassing was that an FBI agent says they don't have the resources to keep their eye on an individual. This is allegedly an individual that committed a crime that they then didn't watch to see if the guns were present, if the jewelry was present. And what didn't we hear today? What we didn't hear today is there is no contract, this mystery contract. They have no contract. They have no video of this alleged signing of a contract. They have no guns. They have no jewelry. They have none of that physical evidence. What they have is they have allegedly 5 individuals, one of them being a very well-known individual that is allegedly cooperating with the government and making these allegations against my client and many more. I'm going to take like 1 or 2 questions and then we're going to scoot.
You're essentially arguing they've got only a he said kind of case, no evidence.
Correct. Yeah, it's very fair. I think that this is it's a he said type of case. I mean, obviously there's 5 individuals on one side. What we're missing are the other people that were present in the room, right? The owner of the studio who says he didn't hear anything or see anything. The way they leave the studio where no one is in concert with anybody else, no one's arguing with anyone else. One of the individuals says, "Hey, can I get my watches back?" Like, the story is quite unusual. And I think that the FBI knew that. I think the investigators knew that it was unusual. And I think that's why it took so long to make the arrest.
What is your response to the judge saying that, your client still violated the terms of his make monitor location?
Sure, those are all things that are going to be, flushed out. The fact is that he was allowed to be in certain areas at certain times. That really wasn't an argument for today. I wasn't really even going to make that argument. My main thrust of today was to really push on the evidence and see exactly what they had and when they had. How about this? How about the individual who wrote the complaint, who actually drafted the complaint, who was sitting in the courtroom, who's only been an FBI agent for 4 years, does not take the stand. They put someone else on to say what she wrote in her own complaint when she's sitting in the courtroom. And that's done quite often in gamesmanship because they don't want to put a rookie on the stand and be measured by our legal team.
How far away is this from trial?
Oh, who knows? We're going to get discovery. We'll take a look at their discovery. They're going to say it's ongoing. I mean, think about it. They had 3 months to get this stuff. They had 3 months to get warrants. They didn't get warrants that night. They didn't get warrants the next night. They didn't get warrants the next month. They didn't get warrants the month after. They waited 3 months to get warrants on whether or not there's guns, whether or not there's jewelry. How about their cell phones? How about the computers? That gives me great pause when I see a case that takes that long to get warrants, if you believe everything that was said on the evening that it occurs.
Doesn't it have a path out of jail?
So my understanding is the FBI has, over the past 3 or 4 months, has interviewed none of the alleged victims, and allegedly they all have future dates to give statements. But I have no idea if that's true. We're basing it on what the agent said on the stand, that each one of those witnesses from that evening is going to appear and give a statement to the federal authorities.
So RD never made a statement as of now?
Not to the FBI, but that evening it appears from the material that they produced and from the agent's testimony is that RD gave a statement that evening, but since that evening has not given another statement. But the FBI said in the future they're all scheduled to give statements, so we'll have to see.
But I have never, not once, seen a defense attorney stand up in the middle of a federal courtroom, in front of a judge, in front of prosecutors, in front of the defendant's family, in front of the media, and quit. Not withdraw through proper channels weeks before a hearing. Not file a motion to be relieved of counsel through the standard process. Quit in real time, on the record, in the middle of proceedings. That is what happened yesterday in a federal courtroom. Pooh Shiesty's lead defense attorney, a man who has represented high-profile clients for over 2 decades, a man whose reputation in federal criminal defense is among the most respected in the country, stood up, addressed the judge, and said words that sent a shockwave through the legal community that is still reverberating right now. And the reason he quit? Footage. New footage. Footage that was introduced by the prosecution in a sealed hearing that became unsealed when the attorney's withdrawal made it part of the public record. Footage that, according to every legal analyst who has reviewed the available information, doesn't just damage Pooh Shiesty's defense, it destroys it.
I wouldn't be surprised if Pooh Shiesty thing results in very stiff sentences for those involved, especially Shiesty. Shiesty's going to get fucked here. He's going to get a long prison. It's federal. There were guns involved. They will get a Texas judge. They forced Gucci Mane to sign a contract. Lawyers and judges don't play about contracts. Contract law is like the foundation of law. A law itself is basically a contract between yourself and the state and the country you're in. Pooh Shiesty got a second chance. Judges hate when you throw away a second chance. Yes, they do. Pooh Shiesty was on supervised release. Pooh Shiesty had an ankle monitor on. I'm not saying he'll get 30 years, but if he did, I wouldn't be totally surprised. He will get 30 years for this. He absolutely will. He could probably get 20 years for the underlying crime and then 10 years for the gun.
And when the attorney saw it, when he watched it for the first time in that courtroom, alongside the prosecutors who had been sitting on it, he made a decision that no amount of money, no amount of professional obligation, no amount of loyalty to a client could override. He walked away. Let me set the scene, because the procedural context matters here. It matters a lot. Even though Pooh Shiesty is a fugitive, even though he has fled the country and his physical whereabouts are unknown, the legal proceedings against him have not stopped. Federal cases don't pause because the defendant runs. The machine keeps grinding. Motions are filed. Hearings are scheduled. Evidence is submitted. The case builds whether the defendant is in the room or not.
We just watched an organized kidnapping when niggas drove from Memphis to Dallas.
Yeah, that's what I'm saying.
Yeah.
You could get killed in front of the arena.
Pooh Shiesty update. You've heard the rumors about how he's getting arrested and he robbed Gucci Mane. Well, here's what we really know. What we really know is that earlier this week, the FBI executed a search warrant at the house of Lontrell Williams. Not clear if they're talking about Pooh Shiesty Lontrell Williams or his dad, Lontrell Williams Sr., but that house in Memphis was raided. After it was raided, reports came out that Pooh's dad and Pooh were both arrested. It seems pretty clear that he's been arrested. Now, the bombshell report that just came out today out of Dallas is that the DOJ is getting ready to file a criminal complaint against Pooh Shiesty and Big 30 for, get this, a robbery at a Dallas, Texas recording studio where Pooh invites a recording contract executive to the studio to discuss his contract. The report doesn't name this executive, presumably it's Gucci Mane. And that once there, rather than discuss the contract, things get violent. Pooh pulls out a gun and forces this executive to sign. The allegations get crazier, according to the report. Big 30 barricades the studio, doesn't let anybody get out. They force the contract signature. They also rob everybody there with Rolexes and jewelry and whatever else. They get out of there. The feds say saw social media. Some of the perpetrators of this robbery were on social media flashing the stolen goods. What is going to happen with this case? Well, look, presumably Pooh's going to get arrested and charged with maybe a federal court or a state court indictment. Pooh's on supervised release. Supervised release for 3 years, started last year in 2025. He's still got tons of years left on supervised release. He's going to get a violation on that probably, definitely.
Shiesty's defense attorney, and I'll refer to him as counsel throughout this video for clarity, had been representing Shiesty in absentia. This is legally permissible in certain circumstances, though it's unusual and procedurally complex. Counsel had been filing motions, challenging evidence, and attempting to negotiate on Shiesty's behalf even without his client physically present. The hearing yesterday was scheduled as what's called a discovery conference. In federal proceedings, discovery is the process by which the prosecution shares evidence with the defense. Both sides are entitled to see what the other side has. It's a foundational principle of the American legal system. You can't ambush someone at trial with evidence they've never seen.
We're outside federal court here in downtown Dallas for an update on the case that involves the rapper known as Pooh Shiesty, Lontrell Williams Jr., after about a 1-hour probable cause hearing in federal court in downtown Dallas. He has been ordered held, the judge deciding that, yes, there is probable cause that he was involved in the crimes that have been alleged by the FBI. His defense attorneys argued the FBI does not have the guns they mentioned. They do not have the jewelry that they mentioned that was allegedly stolen. They do not have the contract that they say that he was forcing the other rapper known as Gucci Mane to sign to get Pooh Shiesty, the other rapper, out of his contract. But the judge said the evidence is heavy that he was involved in this, that he does have a lengthy criminal history, including gun violations before. So at this point, Lontrell Williams Jr. is being ordered held in federal custody pending his next court date. We'll have other updates throughout the day.
But there are exceptions, and one of those exceptions involves evidence that is classified as late discovery, evidence that the prosecution obtains after the initial discovery period has closed. When late discovery is introduced, the court schedules a hearing to review the evidence, determine its admissibility, and give the defense an opportunity to respond. That's what yesterday's hearing was supposed to be, a procedural step, routine, the kind of hearing that happens in federal cases every day and never makes the news. It made the news. The hearing began normally. The judge, a veteran of the federal bench with decades of experience, called the proceedings to order. The prosecution team was present, 3 attorneys from the U.S. Attorney's Office, plus a representative from the FBI's Atlanta field office. Counsel was present representing Shiesty. A handful of media were in the gallery. Family members of various parties were seated in the back. The lead prosecutor stood and informed the court that the government was introducing late discovery material. She described it as video evidence obtained through a cooperating witness that is directly relevant to pending charges against the defendant. She stated that the evidence had been authenticated by the FBI's forensic video unit. She stated that the evidence had been in the government's possession for approximately 3 weeks. 3 weeks. The prosecution had been sitting on this footage for 3 weeks before disclosing it to the defense. Now, there are legitimate reasons why disclosure might be delayed. Ongoing investigation, witness protection concerns, authentication processes. But 3 weeks is a long time, and counsel's face, according to people in the courtroom, tightened visibly when that timeline was revealed. The judge asked whether the defense had been provided with the material in advance of the hearing. The prosecutor said no, that the material was being disclosed for the first time at this hearing, in accordance with a sealed court order that permitted in-court disclosure under controlled conditions. In other words, counsel was about to see this footage for the first time, in a courtroom, alongside the people trying to put his client in prison, with no opportunity to prepare, no opportunity to consult with his client, no opportunity to develop a response or a counter-narrative. That alone is unusual. That alone had the legal analysts in the gallery exchanging glances. Because while in-court disclosure is technically permitted under certain circumstances, it's rare, and it's the kind of move prosecutors make when they believe the evidence is so powerful that seeing it for the first time will have an immediate psychological impact on the defense. They were right. The courtroom has a large screen used for presenting evidence. The lights were not dimmed. This isn't a movie theater, but every eye in the room was locked on that screen when the prosecutor pressed play. The footage is from a security camera, but not from the nightclub, not from the hallway, not from any location connected to the Gucci Mane confrontation. This footage is from a completely different time and place, and that's what makes it so devastating. According to court transcripts that have since been partially unsealed, the footage is dated approximately 18 months before the nightclub incident, 18 months before Shiesty confronted Gucci, before the hallway, before the escape, before any of it. The location is a private residence, not Gucci's residence, a different property. The camera appears to be a home security system, the kind that homeowners install themselves, positioned in a corner of a room, capturing a wide-angle view. The room is what appears to be a living area, couches, a table, bottles on the table, several individuals present. The transcript references 4 to 5 individuals visible at various points. The lighting is dim, but the camera's night mode is engaged, producing that distinctive green-gray image that security cameras generate in low light. And what the footage shows, over a period of approximately 12 minutes, is a robbery, a planned, deliberate, executed robbery. Not of Gucci Mane, of someone else entirely, a person whose identity has been partially redacted in the public portions of the transcript, but who is described as an individual known to be involved in high-value narcotic transactions in the Memphis metropolitan area. The footage shows Pooh Shiesty Shiesty positively identified by FBI facial recognition analysis, according to the transcript, entering the residence with two other individuals. It shows a confrontation. It shows weapons being brandished. It shows the victim being physically restrained. It shows items being taken, cash, jewelry, and what the prosecution describes as a quantity of controlled substances. And it shows something else, something that made counsel's face go white, according to multiple people in the courtroom. It shows Shiesty firing a weapon, not in self-defense, not in response to a threat. The footage shows the victim on the ground, restrained, no longer resisting, and it shows Shiesty discharging a firearm in the direction of the victim. The transcript notes that the victim sustained injuries consistent with a gunshot wound but survived. The robbery itself is not what broke the defense. Armed robberies, while serious, are defensible. Context can be provided. Circumstances can be argued. Plea negotiations can account for them. What broke the defense is the timing, because this robbery occurred while Shiesty was already under federal supervision related to his original firearms case.
Shiesty sentenced to 63 months, that's 5.25 years, on his federal felony for conspiracy to commit a violent crime or a drug offense using a firearm. He's already served about 1 year. That leaves 4.25 years. Typically, with good time served, participating in certain programs, he can get out after maybe serving 80 to 90% of his time. Look for Pooh Shiesty to be back out and about in less than 4 years' time on the streets. This is an amazing result. He was out on a state charge. He picked up this charge in Florida, which was a federal shooting charge. And then while he had this federal shooting charge, he got another charge for discharging a firearm in a nightclub. That was another federal charge. Prosecutors had recommended 8 years. He got 5.25. He's already served 1 with good behavior.
It occurred during a period when Shiesty's defense team had been arguing in court filings, in motions, in every interaction with the judge, that their client was not a danger to the community, that he was capable of rehabilitation, that his actions were isolated and situational.
And then you take another 12 months off if he does the RDAP program, so that means, which is the Drug and Rehabilitation Program. So that means he could get out in literally about 58 months, just short of 5 years, even though it's 97 months. The office, this office, meaning the United States Attorney's Office, agrees that it will recommend at sentencing that the court reduce by 2 levels the sentencing level applicable to the defense offense level, Section 3E 1.1a of the sentencing guidelines, based upon the defendant's recognition and affirmative and timely acceptance of responsibility. If at the time of sentencing, the defendant's offense level is determined to be 16 or greater, this office will file a motion requesting additional 1 level decrease. So basically what they're saying is, okay, you plead guilty. Because you're pleading guilty in a timely fashion, we'll recommend a 2-level reduction for acceptance of responsibility. If your offense severity level is over 16, you get another point. So in other words, by pleading guilty and not doing anything in contradiction to acceptance of responsibility, you get a 3-point reduction.
And here was footage showing the exact opposite. Footage showing their client committing a violent armed robbery, shooting a restrained victim during the precise period when they had been telling the court he was reformed. People who were in that courtroom describe counsel's reaction in stages. And those stages tell the story of a man's professional composure disintegrating in real time. Stage 1 was stillness. When the footage began playing, counsel watched, motionless, arms at his sides. The way an experienced attorney watches evidence, analytically, looking for flaws, looking for angles, looking for the gap between what the footage shows and what the footage proves. Stage 2 was recognition. According to observers, there was a specific moment, approximately 4 minutes into the footage, when counsel's posture changed. His shoulders dropped. His head tilted slightly downward. The analytical watching became something else. It became the watching of a man who is seeing something he cannot unsee, something that fundamentally changes his understanding of the person he has been defending. Stage 3 was the notepad. Counsel began writing, furiously, not the measured notes of an attorney cataloging evidence. Fast, pressured writing, the kind of writing that looks less like legal strategy and more like a person trying to process what they're seeing by putting it into words, as if the act of writing could create distance between himself and what was on the screen. Stage 4 was the pause. The footage ended. The screen went dark. The prosecutor remained standing. The judge looked at counsel and asked if the defense wished to respond, and counsel didn't speak. For approximately 15 seconds, which in a courtroom feels like 15 minutes, he said nothing. He looked at his notepad. He looked at the blank screen. He looked at the prosecution table. And then he looked at the judge. And what he said next has already become one of the most quoted statements in the history of federal criminal defense. Counsel stood. He straightened his jacket. He placed both hands flat on the defense table, and he addressed the judge. What follows is reconstructed from the court transcript, which has been partially unsealed and reviewed by multiple legal outlets. Counsel said, "Your Honor, I need a moment." The judge granted it. Counsel sat back down. He spent approximately 2 minutes reviewing his notes. Then he stood again. He said, "Your Honor, I have represented Mr. Williams in this matter for a significant period of time. I have done so vigorously, ethically, and in accordance with every obligation imposed upon me by the rules of professional conduct and the Constitution of the United States." He paused. "In the course of that representation, I have relied upon information provided to me by my client and by my client's associates. I have constructed a defense based on that information. I have made representations to this court, representations about my client's character, his trajectory, his capacity for rehabilitation, that were made in good faith based on what I was told and what I believed to be true." Another pause, longer this time. "The evidence presented today by the government is not evidence I was aware of. It is not evidence my client disclosed to me, and it is evidence that is fundamentally inconsistent with the representations I have made to this court on my client's behalf." The courtroom was silent. The judge was watching counsel with an expression that observers described as somewhere between concern and resignation. The prosecutors were motionless. The family members in the gallery were frozen. And then counsel said, "Your Honor, I am ethically unable to continue representing Mr. Williams in this matter. The conflict between the evidence presented today and the representations I have made to this court creates an irreconcilable professional conflict. I am requesting immediate withdrawal as counsel of record." The judge asked counsel to clarify. Was he certain? Did he understand the implications? Did he want time to reconsider? Counsel's response was 4 words. "I've seen enough, Your Honor." He gathered his papers. He closed his briefcase. He nodded to the judge, and he walked out of the courtroom. Not through the back hallway that attorneys normally use. Through the gallery, past the media, past the family members, past every person in that room who was watching him abandon his client in the middle of the most consequential case of the year. He didn't stop. He didn't make eye contact. He walked out the front door and, according to reporters who followed him, directly to a waiting car. He has not made a public statement since. His office has not returned calls from any media outlet. The man who was supposed to save Pooh Shiesty just left the building. Let me explain why what happened yesterday is not just dramatic, it's catastrophic. Because counsel's withdrawal doesn't just leave Shiesty without a lawyer. It does something far worse. When an attorney withdraws from a case citing an ethical conflict, specifically citing that the evidence contradicts representations made to the court, it sends a signal that every judge, every prosecutor, and every potential future attorney understands perfectly. The signal is, my client lied to me. And because my client lied to me, I told lies to the court without knowing they were lies. And now that I know they were lies, I cannot in good conscience continue to stand in front of this judge and advocate for a person who used me as a vehicle for deception. That's what counsel communicated without explicitly saying it. And the implications cascade in every direction. First, every motion counsel filed is now suspect. Every argument about Shiesty's character, every claim about rehabilitation, every assertion that the nightclub confrontation was an isolated incident born of a legitimate business dispute. All of it is tainted by the revelation that Shiesty was committing violent armed robberies during the same period his attorney was telling the court he was on a path to reform. Second, finding new counsel will be extraordinarily difficult. No reputable defense attorney wants to inherit a case where the previous attorney withdrew due to client deception. It signals that the client is untrustworthy, that the client withholds information, that the client will undermine their own defense by lying to the person trying to save them. Attorneys talk, and by the end of yesterday, every defense attorney in the federal system knew what happened in that courtroom. Third, and this is the most devastating consequence, the judge knows. The judge heard counsel's withdrawal statement. The judge understands exactly what it means. And while judges are supposed to be impartial, they are human beings. A judge who has been told through the unmistakable language of attorney withdrawal that the defendant has been lying throughout the proceedings is not going to approach future hearings with the same presumption of good faith. The judicial relationship relationship is poisoned, the defense strategy is shattered, and the defendant is a fugitive without a lawyer. The prosecution described the robbery footage as having been obtained through a cooperating witness, and that phrase, cooperating witness, opens a door that leads somewhere very dark. Who provided this footage? The security camera was in a private residence. The residence belonged to the robbery victim, the individual described in the transcript as involved in narcotics. That individual is not the cooperating witness. According to the transcript, the individual is deceased, killed in an unrelated incident approximately 8 months after the robbery. So the footage didn't come from the victim. It came from someone else. Someone who had access to the victim's security system. Someone who either obtained the footage directly or knew where it was stored. Someone who held on to it for months, possibly years, and then provided it to the FBI at a strategically chosen moment. Now, we already know about one cooperating witness in this saga. The informant from Shiesty's inner circle. The person who flipped. The person whose leaked testimony sent shockwaves through Memphis months ago. But here's what's troubling. The timeline suggests that the FBI had the informant's cooperation long before the nightclub confrontation, long before the escape, long before any of the events that made this story public. The informant was providing information, including apparently the location of security footage from a robbery that occurred 18 months before the saga began, while Shiesty was still operating freely, which raises a question that should make everyone uncomfortable. If the FBI had a cooperating witness inside Shiesty's circle for that long, if they had evidence of a violent armed robbery committed while Shiesty was under federal supervision, why didn't they act on it immediately? Why did they let Shiesty remain free? Why did they allow the nightclub confrontation, the hallway incident, the escape, and everything that followed to happen when they had enough evidence to revoke his supervision and put him back in custody months earlier? The answer, according to legal analysts, is chilling in its simplicity. They were building a bigger case. The robbery footage alone would have added years to Shiesty's sentence, but the FBI wasn't interested in years. They were interested in life. They let Shiesty keep operating, keep committing crimes, keep digging himself deeper, because every new offense added another brick to the wall they were building around him. They watched, they waited, they let it happen, and people got hurt because of that calculation. The hallway incident with Keisha, the FBI could have prevented it by acting on the robbery footage sooner. The escape from federal custody could have been prevented. The shooting in Memphis could have been prevented. All of it. Every violent, traumatic, devastating event in this saga could arguably have been prevented if the FBI had acted on the evidence they already had instead of holding it in reserve to build a more impressive case. They chose the bigger case over public safety. They chose the career-making prosecution over the people who would be collateral damage along the way. And now they're introducing that footage in court as if they're the heroes of this story, as if they didn't sit on evidence of a violent crime while real people were being terrorized, threatened, and shot. The machine doesn't just grind up the guilty, it grinds up everyone in the vicinity, and it doesn't feel a thing. The reaction from Shiesty's support network has been a mixture of devastation and defiance, because the robbery footage creates a fracture that his supporters cannot easily repair. Throughout this entire saga, the narrative from Shiesty's camp has been consistent. Shiesty was the victim, exploited by Gucci, assaulted by someone in power, driven to desperation by a system that failed him. Everything he did, the confrontation, the escape, the alleged murder for hire, was the response of a traumatized young man who had no other options.
Gucci, you a motherfucking snitch, nigga. And you got a young nigga. Now, I want to tell everybody who's saying Pooh Shiesty crashed out. Nah, nigga. When you a G, nigga, you don't give a damn about going to jail. It's you pussy-ass fraud niggas like Woody and Boosie and them who don't want to go to jail. Pooh Shiesty told you, nigga, don't let that dirt verse go to your head. Ain't nobody slime as me. And that little nigga made it come down. It's y'all favorite rapper, the G of all G's, Gucci Man with a body. Gucci got a body. This y'all big dog. This is the nigga who ain't folded. He folded, y'all. If you think he didn't give corroborating testimony with his wife and whoever was done, Gucci had to put the police in, y'all. Well, he was a millionaire. I was a youth activist. But nigga, I ain't been in the streets since I was a kid, nigga. I ain't never been in the streets. I've never been in the streets. Oh man, but you told when you was a kid. So now y'all got Gucci, this grown man, with the FBI paperwork named RD. So now y'all moving the goalpost. Oh, he a millionaire, what you supposed to do? I'm a father with kids that want to stay in my kid's life. So yeah, I'm gonna call the police on the nigga. But I'm a snitch, but Gucci ain't a snitch. It's paperwork on Gucci. It ain't no paperwork on me. It's a video when I was a kid testifying against my co-defendant. and they try to make me a police ass nigga. It's paperwork on T.I., it's paperwork on Boosie, it's paperwork on everybody except me. But Gucci, you a motherfucking snitch, nigga.
That narrative was compelling. It was sympathetic. It was, based on the evidence available at the time, arguably true. But the robbery footage complicates that narrative in ways that are difficult to overcome. Because the robbery didn't happen after the alleged assault, it happened before, 18 months before the nightclub confrontation, during a period when, as far as the public timeline shows, Shiesty's relationship with 1017 was still functional.
Hey, what's up, y'all? Listen, I wanted to make this announcement on 10/17 yesterday, but I just seen like my statement, my P&L with all my artists. You know, it's almost like a whole bunch of shake-up and it's a whole shit show in the industry right now. But when I look at my P&L and me being a businessman, I think that I'm gonna have to release almost all my artists except for Pooh Shiesty and Fujiano. This is a decision I didn't want to make. I thought about it, you know what I'm saying? I could keep all of them under the contract. But I said, hey, fuck it. Let's just make the unselfish decision and, let them take their talents elsewhere. So today, you know what I'm saying, I already reached out to all of my artists, you know what I'm saying, to their lawyers and whatever, and let them know that they're free to take their talents elsewhere. And I'm still looking for new talent to pair up with, you know what I'm saying, Pooh and Fu, and that's where I'm gonna put my focus. And I just wish them the best. And I just want to let everybody know that, because, hey, that's where we at.
If Shiesty was committing violent armed robberies before the events that supposedly drove him to desperation, then the victim-driven to extreme action narrative weakens. It doesn't collapse entirely. People can be both perpetrators and victims simultaneously, as we've discussed throughout this series. But it becomes harder to argue that every criminal act was motivated by trauma when some of those acts predated the traumatic events. Shiesty's family has been quiet since the hearing. The social media accounts that have been vocal throughout the saga have gone dark. The Memphis crews that rallied behind Shiesty after the shooting are still making noise, but the tone has shifted. Less, Shiesty is innocent, and more, the system is still corrupt regardless. The goalposts are moving. The unconditional defense is becoming conditional. And in Shiesty's world, where loyalty is everything, where the support of your people is the only thing standing between you and total isolation, that shift is more dangerous than any courtroom evidence. Because a fugitive without a lawyer is vulnerable, but a fugitive without a support network is already caught.
Anyway, man, what's up with Gucci Mane, man? Hey, Gucci Walk, man. I ain't finna lie, bro. I ain't finna lie, bro. I ain't finna sit here and lie, bro. I'm hurt about this. I'm up about this. I'm real live up about this. He realized just the whole culture up. You realize hurt my feelings, fool. You realize hurt my feelings, fool. You a grown ass man, bro. And you got a whole lot of money. What the f you worry about a chain and a ring and shit for? I know why Shiesty robbed you. If he did. Cause he didn't think you were gonna tell on him, fool. He thought you was street like I did. He didn't think you were gonna put the police on him, fool. You a green ass walk. You a green ass fool.
I want to spend a moment on counsel himself, because what he did yesterday, as dramatic as it was, comes with consequences that extend far beyond this case. In the legal profession, withdrawing from a case in open court is the nuclear option. It's the thing you do when every other avenue has been exhausted and your ethical obligations leave you no choice. And while counsel's withdrawal will be seen by many as principled, as a man refusing to be complicit in deception, it will be seen by others very differently. In the defense attorney community, there is a school of thought that says you don't quit ever. Your client is entitled to representation regardless of what they've done, regardless of what they've lied about, regardless of what evidence surfaces. Your job is to defend them within the bounds of the law, and you do that job until the case is over, period. Attorneys who subscribe to that philosophy are looking at what counsel did yesterday and seeing a betrayal, not of Shiesty specifically, but of the principle that every defendant, no matter how guilty, no matter how dishonest, deserves someone in their corner. By walking walking out, counsel sent a message to every future client. If things get bad enough, I will leave. And for a defense attorney, that message is professionally devastating. Other attorneys see it differently. They see a man who reached his limit, who discovered that his client had used him as an unwitting instrument of deception, who realized that continuing to represent Shiesty would require him to either knowingly perpetuate falsehoods or remain silent about the conflict, both of which violate the ethical rules that govern the profession.
When a lawyer drops a client, is the reason shared with the judge and/or opposing counsel in the case? In other words, can the court be told or opposing counsel be told, well, the client refused to be reasonable or refused to pay me or whatever the reason might be? Well, in Utah, where I practice divorce and family law, the answer is no. Clearly, no. When a lawyer drops a client or stops representing a client, known as withdrawing as counsel for the client, the lawyer is not permitted to inform the judge or opposing counsel as to the reason or reasons why. This is due to the attorney's duties to keep the confidential, 1, the communications between the attorney and client, and 2, the information relating to the representation of the client. See Utah Supreme Court Rules of Professional Conduct, Rule 1.16d. Quote, upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interest, close quote. See also Rule 1.6, and there are many parts to this, but I'll just give you a little snippet.
There's a middle ground, of course. Counsel could have requested a private sidebar with the judge, could have filed the withdrawal motion under seal, could have handled the exit without the theatrical courtroom walkout that turned a legal proceeding into a spectacle. But counsel didn't choose the middle ground. He chose the public exit, the unmistakable statement, the door slam that echoed through the legal community and the internet simultaneously. Whether that was principled or performative, whether it was an act of conscience or an act of self-preservation by a man who realized his client's case was unwinnable and wanted to get out before the collapse, is something only counsel knows. But the image, a respected attorney gathering his papers, closing his briefcase, and walking out of a federal courtroom while his client's future hangs in the balance, that image is seared into the public consciousness now. And it says something about this case that no legal brief or media analysis ever could. It says, even the people paid to defend Pooh Shiesty have decided he's beyond defending. Let me lay out where Pooh Shiesty stands right now. Not where he stood last week, not where he stood when this saga began. Right now, today, he is a fugitive from federal justice, wanted on the original firearms charge, new charges related to the escape, potential charges stemming from the Gucci confrontation and the Keisha hallway incident, a possible murder for hire investigation, and now, as of yesterday, an armed robbery with a shooting during a period of federal supervision. He has no attorney. The most recent one quit in open court. Finding replacement counsel will be difficult, expensive, and time-consuming, and the clock on his case isn't pausing while he searches. The narrative that protected him, the victim narrative, the survivor narrative, the Shiesty is innocent narrative, has been severely damaged by footage that predates the events which generated that sympathy. The support network in Memphis that was his lifeline, the people providing logistical support, communication channels, and emotional solidarity is under attack, literally under attack. Gunfire in the streets, and the resolve of that network, while still present, is being tested in ways that no amount of loyalty may be able to withstand. The FBI has more evidence now than at any point in the investigation. The robbery footage, the airport footage, the SUV audio, the cooperation of at least one insider, the financial trail, the phone records, the surveillance data. The pieces are assembling into a case that by any objective measure is overwhelming. And Shiesty himself, if his SoundCloud track is any indication, is exhausted, isolated, wrestling with guilt over the violence being directed at his people, and possibly, for the first time since this began, genuinely considering the possibility that running was a mistake. The walls are closing in from every direction. The legal system, the streets, the industry, the FBI, even the people who love him most are beginning to waver. And the man who was supposed to be his last line of defense just walked out the door. There is a version of this story where Shiesty turns himself in, where he faces the charges, where the trial reveals truths about the industry that changed the culture forever, where justice, imperfect, complicated, but real, is served. And there is a version of this story where the walls close all the way, where there is no trial, no testimony, no truth, just a young man from Memphis who ran out of room to run. We are approaching the moment where one of those versions becomes reality. And nobody, not the FBI, not the lawyers, not 50 Cent, not Cat Williams, not the internet, nobody knows which one it's going to be.